Okay,
Yeah,
we're recording.
yeah, please go ahead.
Great, thanks, Emily. Uh,
Okay.
Good afternoon, everyone, and welcome to our panel discussion on handling workplace investigations, how to minimize workplace disruption and legal liability. Our panel has three people. We are going to be introducing ourselves, and I was nominated to go first. So my name is Stuart Rudner. I am a lawyer practicing in the world of employment law. My firm, Rudner Law, I should point to that side, my firm, Rudner Law, specializes in employment law. That's all we do. We do all aspects of employment law, and we work with employers and employees. So we're able to see things from both sides. I also spend part of my time as a mediator, so I can see things from a third side, from the perspective of a neutral third party. With respect to what we do, I'll keep this fairly brief because I know we have a lot to cover. A lot of our time is spent, as most employment lawyers spend their time, putting out fires, wrongful dismissal claims, human rights claims, and the like. We also do a lot of strategic work with contracts, policies, and procedures. And one thing I think our firm is known for is our focus on education, educating our clients and anybody else who will listen to us. So we speak at conferences like this. I've written a book, and actually two books, and then contributed to others. And I have also designed a few courses, one of which is called HR Law for HR Professionals. And the reason I mention that is because it always strikes me how much things have changed over the years. Because I designed that course about 15 years ago. It's a 5-day course. And when we started, investigations were, I'll say, a footnote of one small point of one part of one day. Now they are one full day out of 5 in the course. And that just shows how prevalent investigations have become in the world of HR and HR law. I mentioned I've written a book. It's all about just cause for dismissal. It's called You're Fired. And it's amazing how the courts have made it very, very clear that if you are considering firing someone for misconduct, there is an expectation and an obligation that as an employer, you will investigate first. There's an expectation of fairness or of due process. When it comes to harassment or sexual harassment, we have legislation that requires investigation if there's a complaint or even a suspicion of harassment. And we're going to get into all that in a lot more detail. But suffice it to say, for now, there are lots of ways to get things wrong. And the courts are increasing the amounts that they are awarding in damages when employers do get things wrong, which is why it's really important that we understand how to address investigations in the workplace, both from a legal perspective, but also to avoid workplace disruption. So that's as far as I want to go for my introduction. And Kristen, I'll turn over to you to introduce yourself.
Thank you, Stuart. Good afternoon, everyone. My name is Kristen Pennington, and I practice law out of the Toronto office of McMillan LLP, which is a full-service law firm that operates throughout Canada. And my particular practice is a mix of employment and privacy law. So I advise clients on various issues related to workplace investigations, including when and how to retain a third-party investigator, how to design an investigation process that is compliant with relevant Canadian laws, and how to interpret and act on the results of a harassment investigation when it ultimately comes to its conclusion. And prior to joining McMillan, I primarily represented employees. So I also bring that flavor to my advice and thoughts regarding workplace investigations. I'm very excited to be here today alongside Stuart and Eric. I'm looking forward to a really productive discussion about what is an ever-growing topic in employment law and certainly a very busy part of my practice. So I'll now pass it over to my colleague Eric to introduce himself.
Thank you both, Kristen and Stuart. So my name is Eric Poirier. I'm the founder and director of Argus Research Group, a third-party investigations company. My primary focus is I'm a health and safety and environment advisor. I do risk consulting, and I'm also a certified peace investigative interviewer, as well as a licensed and insured private investigator. The reason we're here today is to discuss those very things that Stuart and Kristen both mentioned, is that the handling the harassment investigations in the workplace. In my time, I've done quite a few, and then had to sort of sit on the sidelines after doing the investigation and providing the advice, advising the employer, and then consulting with the employee and kind of sort of bringing that all together. sometimes with the help of the law firms on both sides, or even the union side of things. So my experience sort of is a bit more, or is a bit unique in that sense, in dealing with the union side, with the employees, and then also having my experience as a manager as well. So I've seen where things can go really well, and I've also seen where things can go really, really bad really quickly, if we don't pay attention to historical data and case law and that sort of stuff. So with that said, I would like to start off our question, our Q&A, and the first question I've got with respect to our subject is to Stuart. Stuart, so when an organization, let's say, for example, receives a complaint of harassment, what are some of the key things to bear in mind as they're when and how they are addressed?
Yeah, thanks, Eric. I think that's a great way to start off our discussion. So the first thing I always tell people when they get a complaint or even have a suspicion of harassment or sexual harassment, never react in haste. That's the worst thing you can do in almost any situation. Similarly, if you think you have just cause to fire someone, never react in haste. Take the time to understand the legal and also the practical implications and realities. I think historically, when it came to harassment and sexual harassment, the temptation was often to ignore it, especially if the accused was a high income earner. That's a horrible reason for many reasons we'll discuss a bit later. From a legal perspective, if you receive a complaint of harassment or even have a suspicion of harassment, there's a positive duty to investigate. And just I want to make sure everyone is very clear on this. That includes situations where the complainant says not to investigate, where the complainant says not to do anything about it, even begs you not to say anything. You still have an obligation. It includes situations where there is an anonymous complaint, or even if you have a suspicion, a good reason for having a suspicion without a complaint. You can't ignore it. So that's one thing you should do, is make sure to not react in haste, not ignore it. Don't go to the other end of the spectrum, and instead of investigating, just fire the accused, which we saw a lot of a couple of years ago in the whole height of the Me Too movement. We'll talk about that as well a little bit later, but that's also a big mistake. You must investigate. Investigation can mean many different things, and I don't think I have to explain that to the audience here. But I mean, as I tell our clients, it can be as simple as speaking to the two people involved and documenting your findings in an email, or it can be a process that takes many, many months, involves hundreds of witnesses and thousands of documents. So it will depend on what's appropriate in the circumstances. So what should you be doing when you get this complaint? Remember the purpose of your investigation, which is to determine what happened. It's not to prove someone guilty so you can fire them, or to disprove the allegations so you can avoid any liability on the part of the organization. Courts have made it very clear what are the hallmarks of a good investigation. And they've said things like, it must be unbiased, it must be thorough, it must be timely, it must be well documented, it must have defensible conclusions, and it should include recommendations or action items. And courts and tribunals are penalizing employers that don't investigate either at all or investigate properly. So just a couple of other points in terms of what should you do when you get that complaint. Think about any interim measures that should be taken. First of all, advise the parties. So if there is a complaint, you need to advise the complainant that you're going to undertake an investigation. You also need to advise the respondent, and you should be clearly setting out the allegations. I know there's a common mistake of not laying out the allegations in detail. There's this fear that the accused might now have time to manufacture a story and somehow avoid being found out. You should also consider whether you need to separate the employees. If there's an allegation of harassment, do you need to separate them? And if so, can you do so by putting them on separate shifts or in different locations? Or does one of them have to be sent home? In which case you should think about how that's done and how it shouldn't be done, which I think we'll talk about later. And the next thing, which really leads into, I think, what Kristen will talk a bit about, or does spend a lot of her time on, the investigation plan. So you need to think about, first of all, who's going to do the investigation? Is it going to be internal? Is it going to be external? Will it be a lawyer? Does it have to be a lawyer? And I'll say right now, it doesn't have to be a lawyer, contrary to, I guess, a common myth out there. But it should be someone who is trained in investigations, who is capable of doing it and has the time to do it. And when you're thinking about internal versus external, think about things like the nature of the allegations, the relationship of the parties to the potential investigator. I've always been told, and I love this expression, you should never investigate up. So you should never investigate someone who is, above you in the organizational chart, so to speak. Think about any actual bias or any appearance of bias. And then think about who is capable of taking it on. And the last thing I'll say before I turn this over is think about the end result, which is you want a full report, which should be a self-contained document, which will explain the background, why the investigation was done, what was done, what the evidence was that was gathered, what conclusions were reached, and why they were reached. So you're going to think about the end product and then work backwards. And what we often do, I've done a few investigations, but frankly, I prefer to act as counsel. And my preferred process is that we're engaged from the start. If there's going to be an external investigator, we will be the ones retaining them. And then there'll be either if it's an external or internal investigator, then you have the initial meeting where you lay out the plan for the investigation, who's going to do what has to be done, what has to be reviewed, what should be considered, what should not be considered. Then the investigator, and Eric, you're a perfect example. I know you do extremely thorough work. I've seen your work. The investigator goes out, does their investigation. The counsel should not be influencing the conclusions, but then once counsel has the conclusions, counsel can, when we provide the advice on what do you do with this? Should there be discipline? Should there be training? How do you go about doing it? So that's kind of your end goal. And then you work towards that. And from the very beginning, you shouldn't do it in a haphazard way. And the worst thing is when we get a client or a new client who calls and says, we've already done the investigation, here's the report. And now we've got to try to fix all the mistakes that were made. So I guess before we go on to the next question, Eric or Kristen, did either of you want to add anything to that?
No, I think that was great background. Thanks, Stuart. Eric,
Yeah,
anything on your end?
No, further to what you were saying, it's one of the things that I prefer doing. I'm not always contacted through a law firm. Sometimes I'm contacted. Either there's a Ministry of Labor order that's been given to the business, or the company themselves will call me directly. One of the things that I like to, and then we'll segue into that a little bit afterwards, but the one thing that I want to do and I like to and I prefer to do is have that protection, that privilege. So I sort of caution, and I don't want to use that term, so I'm using it in a way to warn, but I want to let the client know that it's probably more appropriate to deal with the law firm at the onset with respect to being able to maintain privilege. Sometimes they don't want to do that right away, and that's okay, but there's at least I've got that documented and make sure that that's communicated with them in the event that it gets to a certain point where there's going to be litigation and so on afterwards. So that's my only concern there. So
yeah, thanks, Eric. It is a great point. And it's obviously different if you're going to retain an investigator like Eric. At least you know that they're trained, they know what they're doing. But especially when it's going to be done internally, and if it's someone who doesn't necessarily have that training, it's really important to have counsel involved, and you really want that team to have a proper plan and make sure it's executed. So anyways, let's move on to the next question, which is for you, Kristen, which is along the same topic of harassment complaints in the workplace. What are the top privacy or confidentiality concerns that should be considered at the outset of the investigation, and why?
Thanks, Stuart. So there are a number of different considerations regarding confidentiality and privacy to consider right at the very outset of the investigation. So first, I think a really brief overview of privacy laws as they apply to the Canadian workplace is helpful to sort of orient the rest of my comments. So for provincially regulated employers operating in Canada, which will be most but not all employers, there's only privacy legislation applicable to employee personal information in Alberta, British Columbia, and Quebec. So those are the areas or the provinces where you need to worry about an actual statute that governs most employees' privacy rights in those provinces. With that being said, employees in other Canadian provinces can still bring a civil claim or a lawsuit alleging that they have been subject to a privacy-related tort if they believe that their personal information has been mishandled by their employer. Now, provincial occupational health and safety legislation and human rights legislation can also govern workplace harassment, and in some cases can contain provisions that either directly relate to confidentiality during investigations or provisions that have been interpreted by courts and regulators and adjudicators as requiring certain protections for confidentiality or personal information during a workplace harassment investigation. So for example, in Ontario, most employers must prepare a workplace program with respect to workplace harassment. And that has to set out information about an incident or complaint of workplace harassment, including identifying information about any individuals involved, will not be disclosed unless the disclosure is necessary for the purposes of investigating or taking corrective action with respect to the incident or complaint, or as otherwise required by law. So your program has to actually set that out at the very outset so that an employee reviewing that program understands that this is the commitment an Ontario employer is making if they bring forward a complaint and it's investigated. Finally, employees can have certain contractual rights relating to workplace investigations. So for example, Eric's referenced working with unionized workplaces, and their employees might have certain rights pursuant to their collective agreement that you need to review at the outset of the investigation. And in the non-unionized workplace, the employer's own policies, programs, or practices can result in employees having certain rights regarding workplace investigations. So think, for example, of an employee handbook, which many of my clients have, and that set out the procedure that will be followed in the event of a workplace investigation and make certain guarantees to employees around confidentiality and the treatment of their personal information in connection with an investigation. The workplace might also have a privacy policy. And in fact, if you're in Alberta, British Columbia, or Quebec, you almost certainly should have an employee privacy policy. And that might set out how employees' personal information will be collected, used, or disclosed. So that's another document you would want to have a look at the outset of the investigation to make sure you're complying with your own policies. So to summarize, the first step then is figuring out what legislation and what non-statutory requirements or contractual rights apply to your workplace and to the participants in the investigation. So I always advise employers to have a careful look at their own policies and procedures regarding workplace investigations, because sometimes there are protections in there that will go above and beyond what's really strictly required by law. And if you fail to follow those policies and procedures, it can be used to call into question the validity of the investigation and its outcome. So it's really important, like Stuart said, to slow down at the beginning to make sure that you've got a process set up that's both compliant with all of your legal obligations and that is also compliant with your own policies and procedures as they relate to confidentiality, workplace investigations, and personal information. So one common issue that you'll have to address at the outset of the investigation is how you're going to inform investigation participants about the handling of their information during the investigation, who will have access to that information, and the participants' own responsibilities around confidentiality and keeping things under wraps during the investigation. So I know Eric is going to address a bit further how you go about that during an interview with a witness, but it's certainly one thing that you want to be prepared for at the very outset and have a plan to address. Another confidentiality consideration, and we've already started touching on this, would relate to the engagement of an external investigator. So if the investigation is going to be conducted by a third party, this can raise considerations regarding compliance with privacy laws and the sharing of employee personal information with a third party. So any retainer agreement with an investigator needs to be carefully reviewed and drafted to ensure, as we've discussed, the scope of the mandate is correct, but also that the investigator is going to comply with all applicable laws, including privacy laws, and with the workplace's own policies and procedures as they relate to investigations. And then my last sort of general advice with respect to workplace investigations, and it should happen from the very outset, is to strictly limit those who are in the know. So you should really think through at the very beginning of the investigation who at our organization has a strict need to know this information. And often it's a smaller circle of people than what your gut reaction may be. And this list of people might evolve as the investigation progresses, more parties become involved, more information is uncovered, and there are new witnesses. But I find it helps to have sort of a roadmap or at least a chain of command of sorts at the very beginning of the investigation to avoid sort of rushing into and unduly widening the circle of people who know what's happening and might have access to really sensitive information that's uncovered during the investigation. So with that said, I'm going to turn it over to Eric now to sort of dig into the mechanics of conducting a workplace investigation. Eric, can you tell us a bit about how to properly and effectively gather evidence during a workplace harassment investigation?
I can. Thanks for that question. That question actually could be viewed very broad in scope, but we'll narrow it into, let's say, just a workplace harassment allegation with respect to two individuals. First and foremost, we're going to be engaged by either the law firm or the employer. And then we're going to want to review what their policies are, whether they meet or exceed the legislative requirements that they're required to have. We also want to look at their policy statements. We also want to see if they've made these policy statements and handbooks that you've mentioned before available to the employees. Have they received the training? Are they in the know of what the expectation or the reasonable expectation is from the company with respect to their conduct being an employee with that business? And then we'll move along. We'll make sure that we're aware of what those policy statements say, what their expectations are, and ensure or find out for sure if they've made their employees aware of that. As we move forward, we're going to want to speak to those individuals that they've described to us, or the ones that they've told us were involved or they believe are involved. And then we'll set the ground rules right there with the employer and with the individuals that we know to be involved according to the employer. And what I mean by ground rules is let them know that we're aware of we take the privacy and the privilege of being able to do what we're doing very seriously. So when I said before about the policies and procedures and the statements, we're going to meet and exceed those minimum requirements that are required by the province and in the area that we're working, and ensure that we've made them aware that we're moving forward as such. And that agreement's going to be there at the onset. It's all going to be recorded too and documented during our discussion. And then we also go through the due process thing. So with respect to that, they all have to have the opportunity to respond to the allegations, to know why they're being discussed, why they're having that discussion, like you said. What this does is also builds confidence with A, the employer, and B, the individual we're interviewing. There's no sign of us being duplicitous. Also, what this is doing is that it is allowing us for follow-up later on. It also taken away the perception of us trying to inappropriately control the environment there. So when I say that, what I mean is there's going to be, we're removing the idea that we're being adversarial or confrontational, and we're being accusatory with respect to why we're there. We want to make the employer aware that that's the way that we're conducting our investigation, and that's our ethical standard that we're moving along with. We're meeting those legislative requirements, and we're also moving along with that standard. It reduces the liability on us, and it also reduces the liability on the employer. Like Stuart had mentioned before, and you'd alluded to as well, the tribunals, courts, adjudicators, whoever they are, they don't take it kindly when there's an accusatory tone to an investigation or an interview, when it seems to be more of a an interrogation. Basically, when they have that idea in mind before going in, saying we're going to get rid of this individual, before knowing and learning exactly what had happened. So we talked about the privacy and then the interview. The other thing I want to talk about too is providing them with the conclusion, like you had mentioned before. We want to make sure that when we have concluded or when we have finished our interviews or our discussions with the people that we were made aware of, that if there's anything else that was discovered, or if there's anything that was discovered during those discussions, we understand or we reasonably believe that we should be talking to more individuals to be able to better assess the balance of probabilities. We're not going to make that call, but we're going to conclude that with the individual or with the employer and say, there's not enough, or maybe we should be speaking to somebody else because we have two very, very opposing stories. And then now we want to verify the facts a little bit more and be a little bit more, we just want to make sure our due diligence is done very effectively and appropriately. Does that answer the question there?
Yeah, I think it met and exceeded my expectations for the answer to the question. Thanks, Eric.
Now, before we move on to the next question, if there's any questions from the audience, or if anybody else has anything to add to it, Stuart? Or...
I think you covered everything really well, Eric, and you kind of emphasized some of the stuff that Kristen's already said and I've already said. So, yeah, I think you made a really good point near the end there about how, if, as an employer or as counsel, you've got to rely on your investigator, and your investigator may come to you and say, I need to get more information, or some witnesses have identified other people who might have relevant information. And, the obligation is not to interview every single person who might have relevant information. And of course, we often see it where someone is accused of harassment, for example, will say, talk to these 10 people. They will all tell you I would never do that, right?
Yeah.
Those are not necessarily people who have relevant information. But if the investigator does think there's a path to go down, then you're probably going to want to go down it, or you're going to be the one, or I should say the investigator will be the one who might be cross-examined one day as to why they didn't. So I thought that was a really good point that you made before.
Yeah, and in some of the experiences that I've had where we do get that, unfortunately, sometimes it's where there's an implicit bias, perhaps. And you kind of mentioned that before, trying not to investigate up, or it's not appropriate all the time for the individual, the employer to be doing the investigation, because maybe it's the rainmaker, it's the individual that's making, they're making all the money for the business, and that's great. But it's not always appropriate for the business to be making those, coming up to the conclusions, because it could be extremely biased. Mm-hmm. Now, I wanted to segue into the next question for you, Stuart. From your experience and from your side of the table and your interactions, what are the more common mistakes that are made when, how would I word this? So what are the more common mistakes that you've seen during the harassment investigation, whether it's from a third party or from an employer's side of things?
Yeah, thanks, Eric. And actually, I'm going to mention one other common mistake. It relates to what Kristen was talking about before, because she made a really important point that everyone should go and check their policies. And I always say at the end of a discussion about investigations or harassment, go back to your office, or I guess you're now probably all in your office and attend this virtually. But when we're done, go check your policies and see what they say. And specifically, what does it say the organization will do if you receive a harassment complaint? Because I've seen them, and Chris, and I'm sure you've seen them too, where it says we'll investigate within 4 business days. Mm-hmm. And I often say, and this is, I guess we're getting to that time of year again, what if it's December 22nd, right? And now you get the complaint. Or I've seen them where it actually says, the director of HR will investigate your complaint. Mm-hmm. So you never want to overpromise, because you're probably going to underdeliver, and you don't want to tie your hands. I mean, as Kristen said, you have to have a program in place. There has to be a procedure in place by which you will investigate harassment, and it has to be publicized so everyone knows about it. but you don't want to overly restrict yourself. So especially if you're not unionized, you're not negotiating a collective agreement. You have the right to put policies and procedures in place so long as they meet the requirements of legislation. Don't, it's okay to give more when it's appropriate, but think about it. And some people never think about what's in their policies. So that's a bit of a digression, but it's a common mistake as well. So as far as common mistakes, I guess more in the course of investigating harassment, there's quite a few, but I've tried to come up with a few of my top ones. One I mentioned before, not investigating. And it's amazing how things have changed as well when it comes to harassment and sexual harassment. I mean, for many, many years, it was more common than not that if somebody complained about being sexually harassed, they were the ones who lost their job. Especially, as you said, Eric, if it was a rainmaker they were accusing, that was par for the course in many cases. And I still remember when the Jan Ghomeshi scandal broke, that started to change things. But I distinctly remember being, of all places, at a funeral not long after the scandal broke. And afterwards, a bunch of us were sort of milling about and just chit-chatting, of course, talking about Jan Ghomeshi. And we all started off by saying how horrible and how horrific this was, that A, he had engaged in this conduct, but B, that the CBC had allowed it when they clearly knew and allowed it to continue. But then what was fascinating to me was we were a group of about 7 people, and we kind of went around, and every single person in that group, they all worked at different places. Every person could name, or they didn't name, but could think of the person in the organization that you knew you never let a younger female intern work with, or that you never exposed to someone without having a chaperone essentially there. Everyone had that person in their organization, but nothing was done. But then we had Jan Ghomeshi, and then we had, of course, Harvey Weinstein and the Me Too movement. In Ontario, we had Bill 132, which put much more protection in place. We've seen a tremendous shift. And like I said before, in some ways, perhaps too much of a shift, because we went from not believing the victim to immediately believing the victim and punishing the accused, not the guilty, but the accused. And the spectrum seems to be coming more towards the middle, I think, over the last while. But that's a big mistake, is just not investigating. Either way, you need to investigate. The other big mistake, which you've touched upon already, prosecuting instead of investigating. Courts hate this. I mean, there's so many cases where we see punitive damages or moral damages being awarded. It's because somebody was fired for cause because they were accused of harassment. And what the court finds is not only did they not do it, but the employer went into the investigation with the mindset of, we need to prove that they did so we can fire them. And there's some great cases where the evidence is that the investigators, during the interviews, if the witness basically said what the investigator wanted to hear, they'd be praised, and they'd write everything down. If the witness contradicted what the theory was, they would essentially be yelled at because of that. So you got to go in and investigate objectively. Other most common mistake I still see is not reaching a conclusion. This feeling that it's a he said, she said, credibility issue, we can't decide, we don't know. And that's where it gets back to what I said earlier about hiring or using a trained investigator. And that might be somebody internal. It might be somebody in your HR department who has been trained. But a lot of companies just default to, oh, you're in HR, just go figure out what happened. Or they give it to the CFO or someone like that, but someone who has no idea. And then I see the report, which says, so-and-so complained of harassment. I spoke to the person that they complained about. He denied doing anything wrong. And so I've told both of them just that we're aware of it, but I can't decide what happened.
Right.
You have a positive duty to reach a conclusion. That is critical. And that's what our judges do every day. It's important to remember that this is on a balance of probabilities. It's not a criminal trial. It's not proof beyond a reasonable doubt. But our judges every day have to decide which version of events is more likely than not. And you have to assess each party's evidence internally, externally. Is it credible? Is it not credible? And make a finding of fact. Other common mistakes, actually, I've kind of already covered this one, asking somebody in HR to do it when they're not trained or when they don't have time. I mean, I work with HR day in and day out, and I know how busy most people are. So they don't have time to do a proper investigation, even if they are well trained. So make sure whoever you assign to do it is going to be able to do it. As I said before, courts expect it to be done in a timely manner. So that's important as well. Refusing to give the accused the details. I still see this all the time, where they'll be told, they'll told come to a meeting without even being told they're accused of anything, or they're told you've been accused of misconduct, but they don't know what, and then they bring them into a boardroom and it's like an ambush. Courts have been very clear in saying there is an expectation of due process and of fairness. People are entitled to know what the details of the allegation are, not just that you made sexually inappropriate comments, but that on this day in the kitchen, you said, such and such to that person, so that they can properly respond to it. So that's a very common mistake still. A couple more, and then I will wrap up. Assuming that if someone is accused of harassment, that you should immediately suspend them without pay. That's another very common mistake. And as I mentioned before, at the beginning, you should assess whether the parties need to be separated. They may not, but likely if there's harassment or sexual harassment, they should be separated. But that might mean putting them on different shifts or in different locations, different departments. Or if you do have to send somebody home, it doesn't have to be the accused. If it's going to be, it's not a disciplinary action. It's an administrative leave pending investigation. And although this drives employers nuts, it's paid. Because they are innocent until proven guilty. So you can't be penalizing them until you find out if they actually did anything wrong. Last two, not documenting the investigation or not documenting the conclusions. If this ever goes to litigation, you want to be able to defend your process and your conclusions. And that's going to come from proper documentation of what you did and how you reached the conclusion that you eventually reached. And again, you have to reach one. So that's critical. And then not taking action to address any concerns that are raised. So if there is a report that says that there was harassment, or even if there was a misunderstanding of what is harassment, that suggests you need to have some training. And it might be training for everyone, not necessarily an individual, but the report is not the end of the process. So decide what needs to be done based upon the findings. Those are a few of the more common mistakes. I could go on and on, but I know it's already 2:40, so I don't want to go much further. So before we go to the next question, do either of you want to add to
that? To your point with respect to being made aware of why they're being brought into the boardroom, so to speak, another common, another thing that I've noticed too, more so in discussions, and then it sort of became a topic afterwards, was they didn't really consider the charter rights either. They sort of don't really see it or don't think of it because it's a place of employment. So they don't look at that charter side of things, where those are still applicable, where they have that opportunity, they have that right to, if they feel uncomfortable at this point and they're not made aware of it, they can leave if they'd like to. They're not bound to stay there. So that's another thing that I wanted to touch base on as well, because I've seen that happen where they try to make the individual feel as if they have to be there and they have to stay there until they're done. So,
yeah, that's a great point. I mean, I think obviously, if there's a reasonable direction, like someone has to come to a meeting, they can't just say, no, I'm not going to go. Right. But you're right. You can't just make them sit there for 24 hours until they give in and confess. So it's not interrogation. Kristen, do you have anything to add?
No, nothing to add on that one.
Great, then I think the next question is for Eric. So Eric, what are the most important things for an investigator to keep top of mind when conducting an interview, whether it's a claimant, the respondent, or a witness?
One of the most important thing, and from a behavioral context as well as due diligence, is honesty. We've alluded to it already, and it's providing that individual, whether it's the respondent, the claimant, or the witness, with the information and letting them know why they're there. If we're duplicitous or we're secretive or deceptive with respect to why we want that individual to be there in that discussion, and then, like you said, sort of just bombard them, there's a lot of stuff that goes wrong there. First of all, you lose the trust of the individual you need to gain the information from. and you might not get reliable information. Second, if that is a documented interview, which it should be, whether it's audio recorded or video recorded, I prefer to do video. But if it's video recorded and it's shown that that due process and is not there, and we haven't been honest and duplicitous with the individual, the information that is obtained from that point on, there's a high probability of it not being reliable anymore. And like I said, the individual that you're speaking with is probably not going to trust you. So you're going to be working tenfold trying to get that trust back. And there was a question that popped up here. We've answered one of them, whereas how do you conclude on the investigation? So we answered that question with, that's a balance of probabilities, and we need to have that information available, and we might have to speak to more people. So Stuart had answered that question. The other question that came up was, is this more of a fact-finding only discussion or interview? The answer, the quick answer to that question, and the most broad answer to that question is, I'm going to say, is that depends. And the reason I say that is it depends on the circumstances, it depends on the background, and it depends on the context and why we've been called out to investigate. And the reason I'm saying that is that, for example, I get called sometimes for incident investigations that are that involve motor vehicle accidents, or they're incident investigations with respect to bodily injury, harm, or death. So if I'm going out there immediately for an incident that it has caused harm, I'm there just for fact finding. I'm collecting evidence at that point. I'm not going to be conducting an investigative interview with the individual I'm speaking with there. Whereas if we're in a harassment situation, we may be called at the onset to do a fact-finding discussion with the individual and learn what we need to go forward with respect to our objectives, which in that case is just going to be a conversation and setting up the tone for the rest of the for the investigation. When we're doing the actual harassment interviews, then we're doing a fact-finding thing. So I'm hoping that Veronica's question is answered there. As I move forward to give the second point here, with respect to the interviews, Stuart, is on the second topic and the second element there, one of the more important things, one of the most important things is to let the individual tell their side of the story, to let them speak their truth. We may already have information that suggests that what they're telling us may not be true. But it doesn't take away from the fact that we still need to let them speak and provide us with their opportunity, or with their narrative. Why? Because what they witnessed, what they saw, may very well be their truth based on their interaction and their interpretation of the situation. I teach it, or I do another presentation on investigative interviewing, and I talk about the way memory works. And this is where I kind of go with that, but I'm not going to get into that here. But that's why I say that, because you could have a witness to an allegation of, let's say, for example, sexual harassment, and we'll just put it at the, let's say it was a comment that was made, as well as there was inappropriate touching. Well, that witness's account, there might be some truth and there might be some stuff that's just made up, but that's their truth. So we need to give them that opportunity to speak. And then we could later challenge what they're saying with some evidence if it's appropriate to do so. And then also what this does is that it provides us with a more accurate representation of what actually happened. So if we've challenged them with something that we know, and they said, well, I don't recall that, or that's not something I saw, that's okay. It doesn't mean that the person is wrong. The second piece there that I wanted to, or the other part that I want to speak about, is we want to do this to make sure we're not accusatory. So if you let them tell us their narrative and their side of the story, their truth, we could challenge it. We can make sure that we could look for the most appropriate answer and something like you said on the balance of probabilities that is more likely to have occurred, we want to make sure that as we move along, it's reliable. And the reason I say that is to remove any sort of risk and liability to the investigator, the firm, the law firm, if they've retained the investigator, as well as the employer if they're deciding if they're going to be making a decision whether or not to dismiss the individual. Now, we understand that dismissal in the employment world is pretty much compared to capital punishment in the criminal world. So we want to make sure we get things right before we come to a conclusion. So that's why sometimes having to speak to more than one individual is very important, so that we could verify and examine those facts after we've collected them. But we also want to make sure that the facts that we've collected are reliable and they will stand the scrutiny if I'm cross-examined myself as an investigator, or if the lawyer is in discoveries and that information is challenged. Does that answer the question?
Yeah, I think those are great points, Eric. And I think that your point is a very good one, because an employee, from the employment law perspective, an employee's forthrightness or lack thereof during the investigation can also be a really critical factor in determining what disciplinary action or what next steps flow from the conclusions of the investigation. So if you have a respondent who is very forthright, is very upfront, sort of had a momentary lapse in judgment, and you allow them to tell their side of the story, and they're quite repentant and acknowledge their wrongdoing, the outcome of that investigation from an employment law perspective may be very different than somebody who is deliberately withholding information, or who, when presented with information that contradicts certain parts of their recollection, isn't willing to sort of show that there's another possible side to the story, or isn't willing to admit facts or elements that may not be complementary to their interests. So I think that's a great point.
Yeah,
Oh, sorry, go ahead.
No, I was just going to speak to that, like the remorse, showing the remorse, if in fact when they've been challenged, it's been found that they're in the wrong, or what they said was untruthful or deceptive. And the other thing too is that also taking the totality of the circumstances, as well as the mitigating factors with respect to how things that occurred during the investigation process when you were speaking to other individuals. So there's a lot that's involved in that dynamic there. So when you were speaking about when you were saying what you were saying, it just kind of brought that to my head. So
yeah, for sure. And certainly from the employer's perspective, if you aren't giving somebody their opportunity to have their story heard and to participate meaningfully in the investigation, if you're then going to rely on the outcome of that investigation as the grounds for disciplinary action, you can certainly expect that the employee who receives the discipline will be challenging the validity of the investigation. And not only can it lead to the disciplinary action being found to be inappropriate or unwarranted, but it can also lead to other forms of damages. And Stuart, you referenced earlier, punitive moral damages for conducting an investigation in bad faith, for being unfair, for failing to be forthright. And the bar is fairly high for an employee to meet in order for those damages to be awarded, but it certainly is not outside the realm of possibility. So it doesn't have to be a perfect investigation, but it has to be sort of fundamentally fair. And I think part of that is, as you've alluded to, Eric, allowing somebody to have their side of the story heard, whether or not it's contradicted by other witnesses as the investigation continues.
Yeah, I think that's a great point. And I was going to add to that, I see we've got about 55 seconds. I'll just say really quickly, because I mentioned my book before, which we update twice a year. And I see this all the time, where often, all things being equal, the person's response when they're confronted can mean the difference between just cause and not just cause. And remember that when you say you have just cause, you're saying the relationship has been irreparably harmed. You could not trust this person anymore. So it's going to be a big difference if the person does something wrong, but then comes to you. They're forthright, they're honest, they're apologetic, as opposed to you confront them and they're dishonest and they cover it up and basically show you can't continue to trust them. So that's a huge factor. So thanks for bringing that up.
Definitely. Well, on that note, it looks like we're getting the time call. So that concludes our session today, and we hope we've planted some interesting seeds about this